Hello, everyone. Welcome to Court with Chrissy. This man might just want to start a GoFundMe for his attorney fees. It's my first SHE SovCit, and I hope you like it. Court with Chrissy is now in session.
Go ahead and call the next matter, which is Geiger versus Geiger. It is file 24-17904-DM. We have two matters set today. We have, I believe we have a pro-con set. Yes, we do. And we also have a motion to enforce a property settlement agreement that's been filed by the defendant, Ms. Jennifer Geiger. With us, we have, and I unfortunately cannot see people's names. It's too far away from me, but I do see that we have with us, let's see, we have the plaintiff, Kevin Geiger. You're with us, is that correct?
Yes. Can you hear me?
And I can hear you. And also Jennifer Geiger as well, is that right?
Christine is here.
All right. I said, is it Jennifer Christine, but you go by Christine, is that right?
That is correct.
Okay, thank you now. And also we have Ms. Jordan here as well. And are there any other parties that are present in this case? It doesn't appear so. All right, let's go ahead and discuss where we go from here. Ms. Jordan, I'd like to hear from you as to today's motions first. It looks like we have the property settlement enforcement issue that needs to be resolved before we do the pro-con. Is that correct?
We're here on our motion to enter the judgment. I have Ms. Schmelzer. I'm appearing on behalf of Ms. Schmelzer. She has submitted a proposed judgment of divorce to the court. We ask that the court enter it. I have a copy of the whatever defendant has filed. I'm not sure exactly what it is. It doesn't specify what she's asking to enforce, but we are standing by our motion today. There's no reason why defendant she has refused to sign the judgment, which comports and incorporates the property mediation agreement that was signed by both parties on May 7th, 2024 at mediation. She has indicated to us only that she does not agree with the judgment, but has not specified what she hasn't agreed to. As I said, the judgment incorporates the signed mediation agreement of the parties that is binding. There's really no reason for her to refuse signing the judgment. It seems that there's been a long pattern of her delaying proceedings throughout this matter, and we ask that the proceedings, that those delays cease at this time, and that the court enter this judgment, which again comports with the party settlement agreements that were placed on the record in open court, and the mediation agreement for the property is attached to this motion as well. Due to the delays and the unreasonable refusal to sign the judgment, we are also asking for an award of attorney fees to plaintiff for him having to file this motion and for the delay. Thank you.
I object. I sent documents regarding jurisdiction.
Hold on. So Ms. Geiger, this is how this works. I will call on you since you're representing yourself. We're going to talk in just a moment, but you do have to wait for me in order to speak, because we are actually making a word-for-word record. And I need to be careful of that record so that if there's any appeal or any review, that it's clear who is speaking and when. So hold tight. I'll get to you in just a moment. You did file first a document on November 13th that indicated that you called it a motion to enforce a property settlement, and you indicated that there was a new mortgage dated 11/15 of 24 that he was closing on, number one, meaning the defendant, and also that he failed to disclose Grand Traverse Band income, as well as a trailer that he owns. And so as a result of those matters, what is it that you are seeking? What are you asking me to do?
First of all, First off, on the record, I object to her statement that she made. Second of all, the plaintiff has failed to provide me with the pistol that was awarded in mediation and signed upon. Second of all, the information in the plaintiff's divorce paperwork is incorrect. I do not reside in Grand Traverse County. I reside over 200 miles outside of Grand Traverse County. That needs to be corrected. And furthermore, I have never gone by Jennifer Geiger Roundtree. Roundtree was spelled incorrectly in her paperwork. And according to the Michigan law, the plaintiff nor no one else can force me to change my name.
All right, you've listed off a few issues. And first, before I hear from you any further, I need to advise you that you're representing yourself now in this case. It is always smart. It's very smart to have an attorney represent you, particularly in a divorce action like this. As someone who knows the law, knows the rules of ethics, the rules of procedure, the rules of evidence. And the reason for that is because when you act as your own attorney, you're held to the same ethical obligations and the same level of knowledge that someone who's gone to school for 3 years to become an attorney has to have. So I'm advising you strongly to retain counsel with regard to this matter. Are you seeking to proceed now on your own?
Your Honor, I am the general executor of my estate, and I am here on a special appearance in order to settle this matter.
All right, that's not what I asked. Listen to my question. Are you ready to proceed then today, even though I've advised you that it makes good sense for you to have an attorney? Do you wish to proceed today?
Your Honor, I have, in the last 5 months, I have sent 5 notices to participants in this case, including yourself. Never at any time during this 5 months or those 5 notices have the matters in the notices been addressed. Therefore, I'm demanding that jurisdiction be put on the record, as well as oaths and surety bonds for all people present.
All right. So, ma'am, you're not answering my question. You're raising issues that, frankly, are a bit concerning because they don't appear to be part of this particular divorce action. But I'm going to ask you one more time. Are you proceeding today without an attorney?
Do I require due process under the law?
All right. You're
Do I
answering a
receive
question
due
with a question.
process under the legal?
All right. Now, let's get back to my question. It appears to me that you intend to proceed today without counsel. You aren't responding to my question. I hope that ceases now. I'm not trying to box you into something. I'm merely trying to get your divorce taken care of. So let's go ahead and see if we can proceed on it. Back to your motion that you filed to enforce the agreement that you had regarding property settlement. That property settlement is generally, and I assume this is the case, I'll talk to Ms. Jordan here in a moment, generally rolled into the judgment that Ms. Jordan is seeking to enter today. And once that is the case, you will have the ability to enforce if it is not complied with. You're seeking to enforce a property settlement prior to the entry of an order is not procedurally accurate. You do need to wait for the order to be entered to be able to enforce. Now, if there was something in that property settlement that required that, for example, the pistol be transferred by a certain date, well, that's certainly something that I would consider. But otherwise, you do need to wait for the order to be entered, and it's the order that is enforced, not the property settlement agreement. Do you understand that, Ms. Geiger?
No.
Okay, let me explain it to you again. The motion that you filed is called a motion to enforce a property settlement. Apparently, there was a property settlement done that is an agreement signed by the parties with regard to the disposition of their assets. And that's not an order of the court until it is rolled into or becomes part of a judgment of divorce. Now, the judgment of divorce is what has been moved to be entered today. And that's what Ms. Jordan has asked me to approve, the judgment of divorce in this case. Once that is done, if the terms of the property settlement are included and have not been complied with, then you would certainly have the ability to move to show cause why the plaintiff should not be held in contempt of court for not comporting with the terms of the judgment. Do you understand?
I do not, because you signed the property settlement back in May or June. It was signed by you. All other matters within the property settlement were taken care of. Why wasn't that, and why isn't that being enforced? It should have already been taken care of. In fact, I received an email from Ms. Smeltzer with directions on what to do to take care of that item of the property settlement, which I did do, and Mr. Geiger failed to acknowledge any of it. He was given the permit in October, and he refuses to comply with it.
All right, let's go ahead and hear from Ms. Jordan then as to the matters in the motion to enforce the property settlement agreement.
Sure. Well, first of all, I believe in her motion that none of this is specified. She did not specify she was referring to the transfer of the guns, but regarding the transfer of the guns within the judgment, it does say that everyone is to cooperate and sign paperwork to effectuate the transfer of the guns. That is something that is, part of their mediation agreement that was to be incorporated into the judgment, just as you have explained your understanding. That is my understanding as well.
Is there an order in place at this time regarding the matters set forth in the motion that's been filed by Ms. Geiger, Ms. Jordan?
An order, I'm sorry?
Is there an order with regard to the disposition of the marital property that the court has signed already?
The only person that has signed it in addition to Ms. Schmelter and the parties was the mediator, Ms. Linda Marsh Rates. But I do not see that that was submitted and signed as well by the court. I mean, I understand it was submitted to the court, but it was signed by the mediator on May 7th at mediation. And that is attached as Exhibit B to our motion.
Thank you. That would be the normal process. Normally, the mediator will sign and approve it as an exemplar of what it was that was agreed to by the parties. And then I sign it, Ms. Geiger, for your information, I sign it and it becomes an order, it becomes law between the parties once the court's signature is on it. I haven't signed it yet. And I haven't signed it yet because we're waiting for all of the remaining issues in the divorce to be taken care of. Now, so for those reasons, what I'm going to do is deny your motion as untimely. This is the motion to enforce, but I'm not making a judgment on the merits of it, meaning if after the judgment itself is signed, which I understand includes the property settlement agreement, after the judgment is signed, if your husband, ex-husband at that point, does not comply with it for whatever reason, then you are welcome to come back to court on an order to show cause, a request to show cause as to why you shouldn't be held in contempt for failure to comport with that order. Do you understand, ma'am? Ms. Geiger, do you understand? Are you on mute?
No, I'm not on mute.
Okay. All right. So you're just choosing not to respond then?
What response is there?
Well, the response is that I've denied your motion that you brought in November, and I denied it as being untimely because there is no order in place that's being challenged, but I'm not denying it on the merits. That means you can bring the issues up again at some point after the judgment is entered and you believe that your husband is not in compliance with the order. Do you understand?
Yes, Your Honor.
All right, very good. Let's go ahead and proceed then to the motion that's been filed by Ms. Jordan. That motion is a motion to enter the divorce judgment in this case. I've heard argument from Ms. Jordan regarding same. Ms. Geiger, do you have any argument that you wish to make with regard to the motion?
I need a moment, Your Honor.
Sure.
I'd like to know if the plaintiff's attorney and the parties of the court received the 5 notices that have come through since July regarding jurisdiction.
This is an issue that is not relevant to the question that I've asked you. What I've asked you is if you have any argument with regard to the motion that's been filed to enter the judgment. That's the matter that's before the court. Remember, I told you you are held to the same standards of ethics, procedures, evidence, etc., that any attorney is. You're choosing to represent yourself. So I need you to be responsive to the issues that I addressed to you. And that question is to you. Do you have any argument with regard to the motion that has been filed by Ms. Jordan to enter the judgment of divorce?
I'm not trying to dishonor the court, Your Honor.
I didn't say you were. I'm simply asking whether or not you have an argument that you wish to make with regard to that motion.
I'm not here to argue, Your Honor. I want to settle the matter, but I would like the matter of your jurisdiction to be addressed. I am here by a special appearance to handle this matter. And I do require due process under the law. Do I receive due process under the legal? And is there a difference between lawful and legal?
Okay. What I will let you do is make a motion if you wish to regarding jurisdiction, because you're now raising a jurisdictional issue. Jurisdictional issues can be brought generally at the beginning of the case in the first responsive pleading.
I did that. I did that at the beginning of the case.
I'm sorry. Did I call on you? Did I call on you, ma'am? All right. Remember I said we can't talk over each other. So you need to respect the court and allow me to say what I'm going to say for the record, and then I'll listen to what you have to say, okay? So once again, you're raising a jurisdictional challenge. Jurisdictional challenges generally must be filed at the beginning of a case. Let me go ahead and look at the file and see whether you filed a jurisdictional challenge. Hold on. Okay, we're going to go off the record for just a moment, and the court's going to address another matter. We'll come to the pleadings of the parties. There is a counter complaint for divorce that was filed in this case. That complaint does establish, admit to jurisdiction essentially, or a jurisdiction, pardon me, at paragraph 1. and paragraph 2 with regard to the actual marriage of the parties. So it does appear to me that the defendant has waived the issue of jurisdiction by virtue of the pleadings that she filed in this case. So as a result, I find that the issue of jurisdiction is untimely at this point. All right, do you have any other issues with regard to the motion that you wish to argue, Ms. Geiger, at this time, other than jurisdiction?
Yes, I do.
You're welcome to go ahead and make them.
The United States has never held any municipal sovereignty, jurisdiction, or right of soil in Alabama or any other new states which were formed. The United States has no constitutional capacity to exercise municipal jurisdiction, sovereignty, or eminent domain within the limits of state or else.
Hold on. If you're reading something, you're speaking too quickly for us to get this into the record, and I would prefer that you summarize rather than read. We do have several other matters that are scheduled today. So normally a motion like this takes about 15 minutes. Now we're well in excess of that already. So if you could please speed it up and summarize perhaps.
I'm sorry, I have challenged jurisdiction. Anything that was prior to July is irrelevant. That was taken care of by an attorney that was fired for not doing their job properly, which is proven on the record based on what has took place in the early stages of this proceeding. What I was citing is Pollard versus Hagan, 44 USC 213-221-223. No shame.
Is going to have to adjourn this matter. I've got a full afternoon docket, 5 matters to go before 5 o'clock. I'm going to reset it as soon as I possibly can, but I'm not able to hear the remainder of the argument today.
Well, Your Honor, Your Honor, I really hope
we'll
that
reset it and we'll let you know as soon as we possibly can. All right. Thank you all. We'll see you soon.
Thank you, Your Honor.